Okay, great. So everyone, thank you so much for joining today's webinar. I would be remiss if I didn't give a massive shout out to Claire, who is organizing and, as you all know, has been really driving this webinar and these resources for you all at DePaul. So really appreciate Claire for all her help in organizing this event and gathering everybody today. Claire, not to put you on the spot, but if you wanted to say anything before I get started, please feel free.
Sure, thank you. For any of those who I haven't met yet, I'm Claire. I'm the Tech and Data Career Coach here in the Career Center. So if I haven't met you, I'd love to meet you, talk about anything career related. So stop on in. But we are really thankful to have Irene here today. She's going to be really helpful, probably answer a lot of your questions. But anything that she doesn't answer today, I'm happy to chat with you about. So thanks so much for coming today, Irene.
Yeah, you're welcome, and thank you so much, Claire, for that intro. I guess I will go ahead and introduce myself. I am Irene Lee. I'm a senior immigration attorney at McEntee Law Group. We are based in Chicago, Illinois. We have been in business for about 15 plus years at this point. And our founding partner, actually, Fiona McEntee, happens to be a DePaul alum. So DePaul holds a very special place in our hearts here at this firm. And it's always great to meet the students here and work with the staff. So thanks again for having us. Um, I'll kind of give a quick overview before we get into the presentation here of my background. So I've been practicing immigration for over a decade now, almost 12 years. And my practice exclusively focuses on immigration, and more specifically, the day-to-day is employment-based immigration and family-based immigration. So today, more relevantly for all of you on the call, we're going to be talking about a couple of different changes that have been going on with immigration under this new administration. And we are also going to be focusing on probably the visa that many of you guys are curious about or have maybe heard the most about as an F1 student, and that is the H-1B visa. We're going to discuss kind of what the H-1B visa is. We'll also go over things like how the process looks to get an H-1B visa, especially if you've never held one before. And then we'll also touch on a couple of other options, immigration options that you may or may not have heard of, but could be potential avenues for some of you after graduation, and as you look towards different options to remain in the US and potentially contribute your amazing talent and skills to employers who need it here. So, without further ado, we'll go ahead and get started. Um, Prior to getting into the meat and the bones of today's presentation, I want to just, this is a little business item that we usually mention at the very beginning of any webinar, which is the webinar information presented today is meant to be general advice, not specific legal advice. So, just note that, of course, this is in a group setting, so we don't have an attorney or client relationship. However, we will get into a portion of this presentation where you will be able to ask questions. And I want to encourage everyone who has any questions to go ahead and feel free to, chime in during that period of time. I should also mention, however, if you have any specific questions about your immigration situation, any sensitive information, we don't want to have you disclose that in a group setting. So if you are someone who might need very specific advice to you, we will provide you with some information at the very end where you can reach out to us and set up a complimentary initial consultation with our team. This is a special offer just for DePaul students. We'll provide you with that information. So if you do have those burning questions about your specific case, rest assured you'll be able to reach us after the webinar. So this is a very quick high-level overview of our agenda today. I mentioned that we will talk a little about the different visa options that might be available to you. And specifically, we're going to really focus in on the H-1B visa program. And one of the reasons why is because the H-1B visa, as many of you probably know, is one of the most popular visa programs in the United States for temporary workers. And it's a very, very natural process to go from H1, or I'm sorry, an F1 to an H1B. But there are several steps that you need to make sure you go through before you secure an H1B. So we'll go over that today. We'll also go over, again, any kind of changes that you really want to keep in mind of during this administration. I know that this administration is known for a lot of um, changes all at once. Let's put it that way. But we're going to go ahead and make sure that you are aware of the main changes that you want to keep in mind as a foreign student, and as potential, H-1B holders or other visa holders in the near future. And then last but not least, we'll go over Q&A for the group so that you can ask your specific questions. So as we get into today's presentation, I'm going to start off by just going over a couple of terms that I may toss around casually, and I want to make sure that I'm being mindful that these terms are not really intuitive, and sometimes they're not really things that are obvious if you're not kind of day to day in the hum-ho of immigration here in the United States. So the first term is non-immigrant. And non-immigrant usually is used in the context of immigration work when we're referring to a non-immigrant visa. And when we say non-immigrant visa, what this means to the government is that you're securing a visa where it's not related to permanent residency, or i.e. the green card. So in other words, you're a temporary worker or you're a temporary visitor. So examples of non-immigrant visas could be B1, B2, business visitor, or business tourist visas. Another type of non-immigrant visa is an F1. That's not green card related, so it is a temporary student visa. H-1Bs are also non-immigrant visas, and so on and so forth. Immigrant visas, you can probably guess, is the opposite. So these are visas that you receive to and for the purpose of permanent residency. So when you file an immigrant application, or a petition is what we call it, that's usually referring to some stage of the green card process. And so some of you might also be curious about the green card process as a long-term strategy, and we'll touch very briefly on that. But again, if you have more questions specific to that, you can always reach out to us for a comp consult. Now, this slide kind of goes over a very high level list of what I like to call the alphabet soup of visas in the United States. We have all kinds of letters are associated with different visas. Sometimes it can be very overwhelming, even for someone like me who does this every day. Um, but the main thing to keep in mind is there are really two buckets. You're either doing a temporary work visa or temporary visa, that's a non-immigrant visa, or you're going for the green card. So I'd like to think of it as two different buckets in that sense. And we've laid out both things here. So we'll go over a couple of them, and some of them you may already be familiar with, especially the international students and work authorization section. You're all probably very familiar with the term CPT, OPT, STEM OPT. This relates to work authorization options for F1 students. So CPT, OPT, STEM OPT are all associated with your student status and your program. General employment-based options. This is not related to F1 students, but these are separate temporary work visas that you can potentially be qualified for. The H-1B, I'm sure many of you guys know what this is, and we just talked about it. The H-1B is a temporary work visa here in the United States that we'll go over in more detail in the slides that follow. The O1 is another temporary work visa. It's a visa that you may have heard about, but many people have a lot of misconceptions about the O1. And interestingly enough, our firm actually, does a lot of O1 cases. And whereas, you may find firms that don't do as many of these types of cases. And the terminology for this type of visa is called an extraordinary ability visa. And what that means is that the O1 is meant for individuals who can demonstrate that they are at the top of their field by a number of different factors, including things like, critical roles at different companies that you've worked for. Perhaps you've filed a patent, or you've developed some kind of original technology. Perhaps you've gotten awards or recognitions for your work. You've been in the press, etc., or you've authored articles, or have been invited to peer review articles. These are the kinds of things that often make up an O1 case. So some of you may be qualified for this. And so if the H-1B is something that doesn't work out for one of you or some of you this year, the O1 is worth exploring for those who might be interested in that. The L1 L1A and the L1B visa is another temporary work visa. And the general nuts and bolts of this visa is it is attached to your employment history, and it must be for employment when you're offered a position with a company in the United States that has a foreign subsidiary or branch or parent abroad. And you must show that you've been working for that foreign entity overseas for at least 1 year in a specialized position or a managerial position before coming to the United States. So this may be less applicable to many of you since you've been here on F1 status. But of course, we don't know your whole employment history, so it's very possible that maybe one of you or some of you could have an L1, that's an option for you. Um, the country specific options. So there are some visas out there that are specifically meant for individuals of certain nationalities and countries. And that's because most of these visas are derived out of a framework either through a trade agreement of some kind or some sort of treaty. And though this is part of the negotiation and compromise of that treaty, one of the benefits is, we're going to have a treaty, we're going to have an agreement between these different countries. Let's exchange knowledge and workers and services and allow nationals of each of our countries to come to the other and provide work for U.S. employers. So that sort of forms the basis of many of these. The TN visa is a visa meant for those that can show citizenship from Mexico or Canada. The E1 and E2 visas are for treaty trader countries. So if there's a certain list of enumerated countries that have treaties with the United States, and if you are a national of that country, you may be, it might be worth exploring an E1, E2. These are for investors who are investing a substantial amount of income into a business here in the United States. The other one is meant for treaty traders who are essentially performing a role that allows for the exchange of services or goods or products between the US and that treaty country that you're from. Um, Now, the H-1B1 visa is for Chilean and Singaporean nationals, and the H-1B1 visa is very much like the H-1B in terms of, what it takes to be qualified. It's just that added step of also showing that you're a Chilean and Singaporean national. The other big distinction between the H-1B and the H-1B1 is that the H-1B has a time limit on the amount of time you can stay in the country on H-1B status. Is a total of 6 years. The H-1B1 doesn't have that limitation. However, the catch is the H-1B1 is not one of those visas that you want to stay on forever if you want to pursue a green card, whereas the H-1B does allow for this, and we'll go into why that is a little later in this presentation. Um, the E3 visa is also very similar to the H-1B in terms of requirements, but it is meant for Australian nationals. And then last but not least, the employment-based green card options. This is not related to your temporary work authorization. And so these options don't necessarily give you work authorization off the bat, but these are the long game strategies. These are strategies that you want to start kicking off sooner than later because the idea is not to have you on F1 or H1B or any of these other temporary visas forever if you want to settle down and really set roots here in the United States and contribute your talent. The green card option, there are a number of different employment-based green card options where your employer can sponsor you, or in some cases you can actually self-sponsor yourself if you can show the government that what you're doing meets the standard for that green card and that you will have work coming in to do if you're granted permanent residency. So the PERM refers to the very common three-part green card process if you are getting sponsored by your company. It's very common to have folks who are on F1 go to H1B, and then once they're on H1B, start the PERM. Um, the NIW and the PERM, just to put some context to it, the PERM is a step in the green card process where companies who are sponsoring you for a permanent role must undergo a labor market test before they are able to actually, before the government grants you the green card. It's the government's way of compromising with companies who want to sponsor foreign talent while also being mindful of U.S. workers who might be qualified for the position and protecting U.S. workers for those job opportunities. So The perm process requires the company to go ahead and recruit in the US labor market and see if there's anyone that's a US citizen or a permanent resident that could be qualified for your position. This is just step one of three, but that's the most recognizable step. NIW refers to something called a national interest waiver. Some of you may have heard of this as kind of like a holy grail to skip the perm because the perm does take several years to process. And many of you, understandably don't want to wait that long. And so the NIW refers to the second step of that standard three-part process to the green card. And it's the form number is called I-140. And the NIW is an option where you can skip step one and go straight to step two. You can also self-petition. The NIW is really around showing the government that what you're doing is of national interest or should be of national interest. So, for example, advancing technology like AI development, or let's say infrastructure, or let's say, policy work. Some level of some kind of industry and work that you're doing that the US government should care about or has noted that is a priority on their agenda. That's what the NIW is for. The EB1 route is EB stands for employment based. Number one stands for the first preference category. So when you deal with employment based green card options, there will be EB1, EB2, EB3, EB4, etc. So the NIW is actually technically classified as an EB2, meaning in theory, it should be that EB1 is the fastest, EB2 is the second fastest, EB3 is the third fastest. It's not always the case, but EB1 is what many people want to vie for if you qualify because it's usually the fastest. But it also, of course, has the highest legal standard. And so these are a lot of times EB1s, people who are on an O1 extraordinary ability visa may try to shoot for an EB1 because a lot of the standards for EB1s is very overlaps with the O1 requirements. So these are some examples of employment-based visas, certainly not the only ones, but again, something to think about in terms of your long-term immigration strategy. Now we are going to go into kind of talking a little bit about international students and work authorization. One question that comes up quite a lot when we are consulting with international students is, you've graduated, you're ready to take on the world and change the world, probably many of you, with all the skills that you've gained from school, and all the brilliant talent you already have. But you're like, okay, well, how do I change the world if I don't have work authorization? Or what do I do to that? Maybe I want to found my own company, but I know that I need a visa to do that. So oftentimes we get the question, what's considered work for or employment for immigration purposes? In other words, how far can I go with maybe starting up a tech startup before I actually need to get a work authorization visa? Um, because of course you don't, one thing you want to always avoid and be very careful of is no matter what visa status you're in, is making sure that you don't engage in anything called unauthorized employment, i.e., performing work when you don't actually have explicit work authorization from the US government to do so. The US government is very strict on things like unauthorized work. So that's something that you want to just be very careful of. Obviously, many of you who are in F1 status have work authorization through CPT, OPT, or STEM. Um, but, um, you know, this question gets brought up a lot in the context of maybe F1 students who want to found their own companies. So to answer the question, what's considered work? The truth is that there isn't a very clear definition of what's considered employment in the immigration context. Now, the government and the regulations don't actually specify what that means. However, we sometimes borrow definitions from other parts of US law, like tax law, to give you as much guidance as we can so that you sort of avoid hitting that line about what might be improper. And the rule of thumb is this. Usually, any activity that you would perform that would ordinarily be paid work for that organization or for a company could most likely toe the line that that would be considered work. It does not matter that you're not paid for it. So even unpaid work can be considered unauthorized work. So something to keep in mind if you're unsure of this question and you're dealing with a scenario in which you want to pursue some form of opportunity, whether it's starting your own company or working for another company, and you don't know what line that you're towing, make sure to seek legal advice or talk to your DSO in your international exchange student office before you engage in any kind of work like that, because you want to make sure that you're being very careful about not stepping over that line. Um, I have some definitions here. I'm not going to bore you with it too much, but the general tax definition is performing services in exchange for some kind of value. So it doesn't always have to be money, but that's the general tax definition of work, and that's usually how we kind of define this in the immigration context. Um, and so I kind of went over, it doesn't have to be paid necessarily. So when in doubt, just definitely reach out to your teams and your legal team and your DSO team before you engage in anything that you're unsure about. Okay, now we're going to go ahead and discuss the H-1B program. I also want to be mindful of the time, so I will probably talk a little bit quickly just to make sure we reserve as much time as possible for you all who have questions. But the nuts and bolts of this is that the H-1B visa is meant for individuals who are offered a temporary job in the United States by an employer in a position that would ordinarily require a bachelor's degree in a specific field or higher. And the flip side to this is that you, as the candidate, must possess those that credential. The last requirement of the H-1B is that the H-1B employer must be able to pay you the minimum or prevailing wage. We call it the prevailing wage in in the immigration world. The minimum wage set by either the government or a third party wage survey. And usually the minimum wage, there is a government website that you can go on and you can look it up. But it's dictated by, things like where you're working, what job you're going to be holding, of course. And then the government has a survey where you can take a look at what their minimum wages are. The wages go from 1 to 4. So wage level 1 is usually entry level roles, wage level 2, 3, 4, 4 being the most senior. And so depending on, what kind of position you're accepting, the wage level is assessed based on, how senior is the role, what are the minimum requirements, etc. Um, so a very cookie cutter example of an H-1B visa is for someone who graduated in a bachelor's degree in computer science and is being offered a job as a software engineer at a tech company. The position as a software engineer usually requires some formal training, like a bachelor's degree in a related field, so software engineering and computer science. And if you have that degree, you would at least facially qualify. Um, Now, job title and founder roles, this is a question that comes up a lot. So this is more about strategy for an H-1B. Most of the successful H-1Bs will have a very specific title or duties. So very kind of CEO is obviously a very popular title and one that exists in almost every company, but the reason why CEO sometimes can be problematic for the purpose of an H-1B visa is because the CEO, just like let's say like a customer rep or an account executive, they're a little bit general and broad, and so at least that's the way that the government has um, viewed these types of positions historically. So unless you are a CEO with an MBA degree or a very obvious kind of business management degree, sometimes it can be challenging to place yourself in a position like a CEO if you have like an engineering degree, for example. Founders and owners can now, this is actually a change from last year, but the H-1B rules as of last year have relaxed a little bit to allow people who are starting their own companies, so founders, to sponsor H-1B visas through their startups. So this was in the past, it was a lot more problematic to do that because part of the H-1B rules required that you show a valid employee-employer relationship. And obviously, if you are a founder and you have a majority ownership in the company, it's really hard to see how the company could fire you or really control your work. So that has since changed. So if there are any founders out there in the crowd, reach out to us so we can talk a little about what this might mean if you're interested in the H. Visa duration for the H-1B is 6 years total, like I mentioned earlier. They are granted in increments of 3 years. And in addition, anytime you spend time overseas traveling, you can actually use all of those days and add that back to your total 6 years. Um, even though there is a limitation on the H-1B, I mentioned earlier that it's very common for folks who go on an H-1B to start the green card. And the reason for this is because if you reach a certain segment of the green card process while you're on H-1B and before you run out of time, you may be able to extend your H-1B even beyond that 6 year limitation. Um, while you're waiting for the green card to finish up. So this is a benefit that the government grants to H-1B visa holders because they recognize that 6 years just sometimes isn't enough to get a green card because of government backlogs and how long it takes. So that's kind of the visa duration, but there is that exception if you go through the green card process. For family, those of you who might have family members, spouses, children, if you're on an H-1B visa, there is a dependent visa for your spouse and child. It's called the H-4, and certain H-4 spouses may qualify for work authorization. That goes hand in hand with starting the green card process as an H-1B holder, and that middle segment that I mentioned will allow you to extend your H-1B beyond the 6th year of the green card. That also allows your H-4 spouse to get work authorization. So there's a lot of benefits to starting the green card process as soon as possible when you're an H, because it takes a couple of years to get to that stage, and you want to leave yourself enough time. Last but not least, the H-1B is what we call a dual intent visa. And that means that the H-1B is one of those visas that the government is okay with you pursuing a green card. There are some visas that it's technically not allowed, and F1 is one of them. This is what we call a single intent visa. The visa program was designed so that you could go to school, and eventually it was meant to be temporary. But the H-1B visa does allow for green card intent. So that's another benefit of the H. Now, the H-1B visa process, there is a limit on the number of H-1B visas that the government is allowed to give out every year. And so this process of selecting who those visas will go to every year is called the lottery process. And so there's a total of 85,000 visas that the government will give. 20,000 of those are reserved specifically for individuals who have completed a US master's degree. So that's preference that's given to people who have gone to graduate school here. And because in the past, historically speaking, more than 85,000 people apply for the H-1B, this is why the government conducts this lottery process to try and make it as fair as possible, to select who will be invited to apply for a new H-1B visa that year. So this registration process is actually ongoing right now. The window to register, this is step one of two in the lottery process. Step one is registration, where you simply put your name in the pot. This is done through your employer, so you yourself as a student can't register yourself. But if you have an employer who wants to sponsor you in the H-1B visa lottery this year, we would work directly with your employer to put your name in the pot. Now, this registration period is only open for a 2 week period. And actually, just very recently, the USCIS did announce the official dates for this year's period. So it will be March 4th to the 19th this year. If you have employers who are interested in sponsoring you, I highly recommend reaching out to us ASAP. We are having a call out for new cases up until February 20th, which I know is not very far from now. Um, and so if you are interested, please let us know. The process really requires some prep work from the company. It is wage-based this year, which is a new change from years past, meaning the offered salary that you are getting from your H-1B employer will play a factor in the odds of your probability of getting selected. If you are selected in the lottery process, in the registration process, we will find out once you kind of submit your name in the pot during that 2 week period in March. The window will close and the government will conduct that selection process, and they will announce who's received a selection by the end of March, so that those who have been picked in the lottery can start filing H-1B petitions between April and June. So being selected in the registration doesn't mean you automatically get approved for the H. You do have to still go and file a petition and get that approved. But it's a really good sign because historically speaking, um, people were about selected at a 30% rate, which isn't really high. This year, I have a prediction that we're going to get a higher selection rate for a number of reasons. So if you are interested in applying, especially if you have a U.S. master's degree and an employer who will sponsor you, highly recommend this. Two main changes for this year is many of you may have heard about this thing called the $100,000 fee that applies to H-1B holders. I want to assure all of you on the call that if you are in valid status between now and October 1 at the very least, you should not be subject to this $100,000 fee. That's assuming that you want to go through the process this year and you get selected. This is really meant to apply for people who are abroad or are not eligible to change status here in the United States from whatever they are in to H-1B. So it's actually a minority of people who go through the CAP process. And then we discuss the wage-based selection process. And so that will also play a factor, and that's a new thing for the year. Couple of nuances, especially for those of you who have F1 OPT or STEM OPT that's expiring sometime in the middle of the year. This is what we would call a cap gap applicant. And so if you go through the lottery this year, you're selected, and let's say your OPT or STEM OPT expires in May. And so you don't have enough to bring you to October 1. That's okay. We would file your application before your OPT expires to ensure that you get this benefit called cap gap. It's an automatic extension from the day of your OPT expiry until next April. And so this is meant to cover any time that any gap of employment you might have otherwise if you have an H-1B pending. The catch to this is that if you are a cap gap candidate, you of course need to file that petition before your OPT expires. And then number two, you must not travel. You must stay put. If you travel, that would abandon your cap gap status and you probably would get stuck overseas. So that's something that many of you probably know about, but that's a nuance here. You can do a flexible start date for cap gap subject petitions, but generally speaking, most of you will, the earliest you can change status is October 1, which is the government's fiscal year, the start of the government's fiscal year. Um, Now, there's been some relaxation with respect to the rules about H-1B. So one of those is relating to how closely related your degree has to be to the position. There are strategies around this, so don't worry if you link up with the right legal team. They will help you kind of go through this. You and your employer strategize the right kind of format for your position. The other thing to note is that CAP exempt employers, so some of you may or may not have heard of this, but there are certain employers, including institutions of higher education like DePaul. There are certain employers like nonprofits that have a research focus, government institutions that have a research focus, and universities. Um, these are public universities. These are employers that do not have to go through the H-1B lottery process if they hire you. So if you're in that pot where you're kind of looking at different employers, this could be an option for you, and you could bypass the lottery. Um, Changes to anything related to your H-1B position, worksite salary can trigger potential requirements, including a new filing. So that's something to be mindful of. H-1Bs are tied to a specific employer and work. Additional requirements related to maintenance status and third-party worksite. We won't go too far into this. This is much more nuanced than I think probably this presentation needs. But suffice it to say that you can work at different third-party work sites. There just is additional documentation you might need to show the government. Um, and one other thing to mention, we'll go over this a little bit later in the slideshow, is that there are just more enforcement measures under this administration. So many of you might have heard about this, but F1 students and H-1B holders are subject to social media vetting if you go to apply at a visa, go to apply for your visa at the U.S. consulate. So just something to keep in mind there, that if you don't have to travel, we wouldn't recommend it at the moment, just because there are so many different changes and there are a lot of delays being reported all around the world. So we'll get into that a little bit more, but those are some of the nitty-gritties, and now you're basically all H-1B experts at this point. So now we're going to try and zoom past some of these changes. Um, Quick things, most of the crux of this is there are a lot of changes. It's true. And it's, as students, and we wouldn't expect anyone who's not actually doing immigration on a day-to-day basis to really be able to keep track of all the different changes happening. Frankly, even as an immigration practitioner, it's difficult to keep track of all the different changes. I think I'll leave this by saying there are a lot of changes, but there are also a lot of creative advocacy and strategies that your legal teams can employ because number one, this is not the first time that we've gone through a Trump administration. Yes, this administration is still doing things that are unprecedented. That's true. And we have to work within the means that we have and the law and the framework that we have. But there are a lot of creative strategies still out there. H-1Bs are still getting approved. People are still getting visas. People are still able to travel for the most part. So all that said, I know sometimes immigration, especially what's being splashed in the news, can be, for lack of a better term, depressing. But I really want to leave you all with a positive note and let you know that there are plenty of resources. Your exchange office, as one great example, and Claire and everyone at DePaul, as well as our team that can kind of help you navigate through a lot of changes. The main thing I would just say is just be very careful about what you're posting on social media. Social media is now being very tightly screened by officers at the borders, at the consulates, etc. It's now a requirement at the consulates. Other things to keep in mind is if you do travel and you plan to get a visa stamp at a consulate, make sure you're doing it in your home country or your country of residence where you can prove residence. That's a new change from the Department of State late last year. So going to Canada because it's more convenient when you're a Chinese national is not recommended. Your visa application could get denied, it could get rescheduled, etc. Other things to keep in mind is if you do decide to go travel, just keep in mind that you may want to be prepared for delays overseas, etc. We are hearing reports of individuals who are scheduling visa appointments and their consulates are kind of abruptly rescheduling for 6 months out. I even had a client tell me that their consulate rescheduled them till April 2027, which was, over almost a year and a half. So just something to keep in mind. These are the reasons why, we don't want to throw a wrench in your spring break plans, but this is the reason why we're exercising a lot of caution when people tell us that they want to travel. Hawaii is great this time of year, so any U.S. territory is okay, but we just be very cautious about international travel right now. So this was a lot of the things that I kind of already mentioned, which is, if you have questions, please reach out to our team, your DSO, be very communicative. I think one of the biggest things that is the most helpful and impactful thing is to, when in doubt, ask your team and talk to your team before you take action. Oftentimes, we get folks who kind of come out and reach out to us after they've done the thing that they're unsure about. And at that stage, depending on what the thing is, we may or may not be able to do a lot to help out. So we just really highly encourage you to be super communicative with your DSO team and legal teams if you have the need for some legal advice. Um, Avoid international travel again. Like I said, if or unless it's urgent, um, be mindful of your social media. Stay informed, but obviously, again, we don't expect you all to know all the digest of immigration news, but you can always reach out to, again, your school or our team, and we'd be happy to give you advice. And then, I know AI is super popular. I use it too. It's really cool, but the amount of times I've had clients who have come to us with some issues because they listened to AI, or at least they kind of used it as a crux. Um, but then ended up having some problems after. I have too many to count at this point. So I really highly encourage you when in doubt, AI can be an amazing tool for a lot of things, but your legal status is just not worth it, taking the risk. So I highly encourage you to take advantage of our comp calls and reach out to us if you have specific legal questions. Okay. Now that was a lot of information, and I'll admit that actually that took a lot longer than I wanted it to. So I really apologize about that. But hopefully, um, many of you took away something that you didn't know, and something that was useful for you today. But before, we close for the evening, I'd love to turn it over to the Q&A, and so that we can get some of your questions answered.
Thank you, Irene. I learned a lot, so I appreciate it. A few questions have come in the chat box. If you guys have more, please feel free to put them in the chat box and I will read them out to Irene. The first one came in when you were talking about like kind of more the alphabet soup stuff. So is the L1 application or applicable even after you have resigned from that company in another country, but you get a job offer from a branch of it in the US?
Excellent question. Potentially, yes. So the rule behind this is you need to show that you've been working at least 12 continuous months for that foreign employer in either a specialized or a managerial or executive position abroad before you came to the US and within the 3-year time frame that you're applying for the L. So in other words, example, let's say you work for what's a really big conglomerate, Starbucks corporate. Let's say you work for Starbucks corporate over in Japan about a year and a half ago, and you were working about a whole 12 months and you were a manager of a particular function there. And you quit because you wanted to find yourself here in the US, but then Starbucks, like, we can't lose you. We really got to have you join us here in the US. And maybe it's been 6 months since you've been with the company. In that scenario, we could potentially get you an L1 because as long as the 1 year period doesn't surpass that 3 year mark, that 3 year window that the government looks back at, it's almost like looking behind you. Um, if it fits within that 3 year window before you apply to the L, yes, it is possible.
Um, for another one, if someone has to travel abroad for more academic reasons, such as like attending a conference and then return, um, what do you think about that? Like how to be cautious, or are there different stipulations around that?
Yeah, I think it really depends. Traveling abroad, for academic reasons is perfectly fine, and that really deals more with the rules of the country that you're going to, right? Whether or not you'd be allowed entry and whether or not you have the appropriate travel documents. I couldn't comment on that, but from the US perspective, there's nothing wrong with you leaving the country to go for whatever reason you want and then coming back, as long as when you come back, you have the appropriate documentation and you're coming back to do the intended purpose of the visa you're requesting admission in. So, for example, if you're coming back on F, the intent should be to resume your studies. Um, the only thing I'd caution in general is, travel right now is not recommended. So if you require a visa stamp in order for you to leave and come back, just as a reminder, if you do travel abroad, you do need a valid visa stamp in your passport in your category in order for you to return to the country, unless you're a national of a visa waiver country, for example, Canada. Um, so in that way, yes, I think you should be cautious about traveling if you need to apply for a visa, because you need to keep in mind that if you do need to apply for a visa, you'll be subject to social media vetting, potentially some of those delays we talked about, etc.
For countries that might be on like a temporary travel ban list, are they still offering H-1B and approving STEM OPT for F1 students from those countries?
That's a great question. So I'll admit it's hard to keep track of all the different bands going on. And on top of it, there's like, here's a band today, and then there's like, okay, we're adding 20 more countries next week. The short answer to this is there are a couple of different bans going on. There is one particular memo from January 1 that does seem to suggest, at least as we know now, seems to suggest that employment-based petitions like H-1Bs and other immigration benefits more generally will be paused for those countries. So those are about 39 countries. They were issued in a January 1 memo this year. And that's as far as we know right now. as many of you who have been following this administration might already know, the reason I put a disclaimer as that's what we know right now is because sometimes the administration can come out with guidance and then backtrack or need to clarify later. So suffice it to say, it's a possibility. So if you're concerned about that, I definitely recommend you reach out for a consultation or, link up with a legal team that has experience in this.
Um, oh, sorry. Ah. Is it encourageable to file for a marriage-based green card if the U.S. citizen spouse is also a student, and hence why the students may or the spouses may not be living together?
So the fact that you're not living together is not a death knell to your marriage-based green card process, if that's what the question is meant to get at. Um, what the government's concerned with when they look at marriage-based green card processes is it a legitimate marriage? Meaning, what the government officer is really just trying to root out marriage scams. And so, there's a number of different factors. There's not just one thing that an officer looks at. They'll look at your entire record and your history together to understand, okay, they may not be living together, but there's a perfectly reasonable explanation for that. But are there other circumstances or factors in your background that maybe suggest that this isn't a real legitimate marriage? Maybe you're not able to provide evidence of your wedding, or there's very few photos of you guys together, or you're asked questions about each other's habits during the interview, and neither of you can really seem to answer anything about each other. So it's a combination of things. Yes, an officer might, if they notice on a marriage-based case that you have different addresses, they will certainly ask about that. So be prepared, because obviously they expect most married couples to be living in the same location. But if you have a reasonable explanation, yeah, real married couples have to live apart sometimes too. So that's not a dispositive factor.
Does an EB2 NIW require a specific education?
EB2 NIW, does it require a specific? That's a great question. It does actually require a specific educational level. So EB2, like I mentioned, is employment-based second preference. In order for you to qualify for that classification, you need to show that you either have a bachelor's degree or a foreign equivalent and at least 5 years of progressive work experience or a master's degree. That's the minimum educational level to qualify for the EB2 green card category. So now you don't necessarily have to have a specific type of degree. So it's not only meant for STEM or whatever, but you do need to show it as part of the NIW application that your degrees are related to your endeavor. So in other words, you do want to show that nexus there. Um, and so that is part of the equation.
So, um, like personally, when do you think a student should consult an immigration attorney more like individually? Obviously, if they have more like personal questions, but when do you think they should get an immigration attorney or law firm involved in their case?
So if I'm being honest, before you even start school, um, and here's why I say that. I say the earlier, the better. There are two main checkpoints, though, I think that would be great. Number one is before you even start school, it's not a bad idea to link up with a U.S. immigration attorney because um, let's say you're not sure what kind of degree you want. But you know that you want to eventually use after you graduate, you want to stay in the country long term and you want to give yourself the most possible options for visa categories that you can. Well, I have clients that sometimes consult when they're still abroad and they're considering applying to universities here because they want to understand, does the type of program I pick matter? Is that going to have any kind of impact on the types of visa options I'll have? And the reality is it does. If you're in a STEM degree, for example, you get that benefit of having that additional STEM OPT extension of 2 years. That could play a huge factor in whether or not you want to go to STEM or you want to get a degree in a social science, for example, that doesn't have that benefit. Um, but outside of that, obviously all of you are here and you're probably, some of you are barreling towards graduation. Congratulations. But if you are already here, my advice would be to reach out to an immigration attorney um, within this 6 months before you graduate. Um, and this is because 6 months gives you enough time to take steps needed to potentially secure employment after graduation and a sponsor for the H-1B, or decide, if you only have one 12-month OPT period and no eligibility for STEM, what's the most important thing you need to do within that first 12 months to maximize your chances of getting another visa afterwards. So I always say the earlier the better.
Um, what do you think, or what records should students keep for like future visa or green card applications? Like, what do you think they should keep on hand, or what do you think they'll need later on?
That's a great question. Definitely retain any and all records of your immigration status. So, any US immigration documents that have ever been issued to you. So, what I mean to say is all your I-20s, even from the very first one, keep all of those. And make sure you scan, make sure you have the original, but you should definitely scan all of them because that's what's going to be used in all of your immigration filings. Keep records and scans of all your EAD, OPT cards. Um, you will eventually, not now, but you will eventually need records of your degree and transcripts. So getting those degrees and transcripts scanned in for you would be also ideal. Um, you also want to make sure that you retain all of your passports and visa stamps, all that good stuff. And this is way further into the process. You don't need this until way later, but you will eventually need, if you want to go down the green card process, you'll eventually need your birth certificates and things like that, civil documents, marriage certificates, etc.
Um, well, that kind of brings us like pretty much to our time. And I want to make sure that you get your last kind of notes in, especially because people have been asking about how to contact you, and how to get in touch. So I'll switch the slides so you can kind of get that in, and then we'll go from there.
Okay, sounds good. Well, again, I appreciate everyone for joining. And again, thank you so much to DePaul University, especially to Claire, for organizing this awesome event. Hopefully, this was helpful for you all in the audience. And if we didn't get your question answered, you can please feel free to reach out to us. We'd be happy to offer that complimentary consult just to DePaul University students for having attended this event. You can reach out to us right on the our website. So we have a couple of different ways you can kind of stay in touch with us. We're all over social media, but you can also go directly to our website, and there is a consultation link that you can select from that website, and you can actually go and book a consultation right then and there. The reason why I'm encouraging you all to not do that, at least initially, is because that consultation link is for the general public. For you all, what you can do is, and I'll just put this in the chat. Um, info@mcentlaw.com is our general intake information. So that's for all new clients who are coming in. Please email that and let them know that you are a DePaul webinar attendee and you're a student and you'd like to request a comp consult with Irene Lee, and then you will be directed to me and we'll go ahead and set you up. So hopefully we'll be able to answer some specific questions for you all who have burning kind of immigration, um, uh, you know, ideas or options that you want to explore. And so I'd be happy to do that with you guys.
Amazing. Thank you so much, Irene. I really appreciate it. And I hope you all learned a lot. This was amazing. I know I learned a lot.
No, no, thank you. This is so well prepared. And again, thank you. Huge, huge thank to Claire. Really, really great meeting you all. And I hope to see some of you maybe graduate and potentially set up consults with us, and maybe we'll work together in the future. But best of luck and continue to, represent the best of our kind of talent here in the US. We really want to support all of you F1 students. So don't hesitate to reach out, okay? Okay, thank you, everybody.